Thank you. I'll switch to English with my deepest apologies for the quality of my English, but the idea was that everyone is going to understand. Let's hope that you understand. If not, of course, I will clarify. Before starting, I just wanted to thank Guy because I think it's really a good transition, because I'm going also to speak about the access to the judge and access to remedies in the context of climate change, especially maritime issues of climate change. So I chose mainly to talk about sea level rise, because it's an issue that is at the meeting point of the sea issues, the climate issue, and of course the human rights issue. So I'm going to talk about the first climate cases that were issued by the European Court on Human Rights in 2024. So we have 3 cases and 3 different judgments that were issued on the same day, April 9th. The Verein Schweiz case. It's the only one in which actually the court considered the application admissible, and it considered itself competent. And we have also 2 other cases that were also climate cases, the Duarte Agostinho case versus Portugal and 32 other states, and the Carême versus France case. So maybe just as an introduction, maybe an explanation of what these cases were about, what we were talking about. So this is the association that brought the case against Switzerland. So it's an association of old ladies. So the complaint was filed by the association, but also by 4 individual women. And they were complaining about the consequences of global warming on their living conditions and on their health. And they argued that Switzerland had a positive obligation to protect their right to life and their right to private and family life, and that Switzerland had violated this obligation by failing to take appropriate measures. And they also said that they didn't have effective remedies to go to a court, to access a tribunal in Switzerland to make their case. In that case, the Grand Chamber of the European Court said that there had been a violation of Article 8 and of Article 6, Paragraph 1. So Article 8 is the one on private and family life, and Article 6, Paragraph 1 is the right to access a tribunal. What's interesting for us, it's mainly that the court said that Article 8 of the Convention encompasses a right to effective protection with a positive obligation for the state. To protection from what? Protection from the serious adverse effect of climate change on lives, health, well-being, and quality of life in general. However, in this case, so it's like a positive outcome, of course, because the court said that Switzerland had violated this positive obligation, and that Switzerland have positive obligations in the context of climate change. But the court did not accept the application of the 4 individual women. It considered that they did not meet the victim status criteria, so we'll talk about that a little bit further. It's a first sign that the access to the court is going to be difficult. The second case is the opposite of the Ferenczi-Signorini case, the Duarte Agostinho case. It's about children, this time, Portuguese children, bringing an application to the court against Portugal, their state of nationality, but also against 32 other states party to the European Convention. saying that they are failing to take adequate measures to combat climate change is causing difficulties in their daily life. For instance, heat waves affecting their living conditions, their health. So they are saying that there is a violation of Article 2, right to life, and Article 8, private and family life. And they also, this is very interesting, they also alleged a violation of Article 14. This article is about discrimination because they considered that their generation, the children, are particularly targeted and vulnerable to climate change. So in that case, the Grand Chamber decided that the case was inadmissible for two reasons. First, because the case against the 32 other states, other than Portugal, was inadmissible because of the lack of jurisdiction of these states over the children. So we'll also go back on the test used by the court in that case. And the second ground for declaring the application inadmissible was the lack of exhaustion of domestic remedies. And it's a very similar case from the Kiara case, but I will talk about that later. So this case was found inadmissible by the court. And the third one was also found inadmissible. It's the case brought by this man. He's called Damien Carême. He was the former mayor of a French town called Grande-Synthe. So it's on the north shore of France. And this case is the only one that is really linked to sea level rise issues, because the problem in Grande-Synthe was the elevation of the sea and the erosion of the coastline and the risk of flooding. The consequences are that some areas of the city are now almost inhabitable. So the Grand Chamber in that case said that the application was inadmissible because of the lack of the victim status of Damien Carême, because he was not living in Grande-Synthe anymore, and because he was not even living in France. So what are the implications? These cases, they are not really maritime cases per se. The courts do not use the law of the sea. The only reference to something that could be interpreted as law of the sea is the reference to the ICLOS advisory proceedings. This reference is made in the Swiss case. However, these judgments, they are, I think, in my opinion, interesting to address situations where we have serious effects of climate change on coastal areas, for instance, due to sea level rise. And the two interesting questions that these cases raise are the access to an international human rights body, how we can access to them, and what are the criteria that the court use for its own competence and the admissibility of the applications, especially the victim status and the jurisdiction. And the second implication that I found interesting was the content of the obligation, because in the Swiss case, the court found that there is a positive obligation, but the content of the obligation is quite different than the interpretation of other tribunals, for instance, ICLOS, which is normal, of course, but just to compare. So first of all, on the issue to access international human rights body, this is a very tricky question. It's the main problem in climate cases. Why? Because it's very difficult to identify which state is responsible for the pollution. Okay, it's of course a global source of pollution, so we could say that every state is responsible for polluting, for the emissions. So it's difficult to say if we are under the jurisdiction of a particular state. And the other difficulty is that global warming and climate change is affecting everyone. So who is the victim? And it's difficult to identify who is going to have the victim status, because potentially it could affect everybody. These issues were already addressed by other human rights bodies before the court rendered its judgments, by UN committees, especially the Human Rights Committee, and the Committee for the Right of the Child, and also by the Inter-American Court on Human Rights. But we will see that the European Court did not follow the path of these previous cases. So I put on that slide some of the cases that I used. You could find other ones, but I think these are the main ones. Some of them were already, we talked about already with the first presentation. And in these cases, the human rights bodies already tried to address these issues of how to access to them. Especially the Kiara and other case is very interesting because it's very similar to the Duarte Agostino case. We have a group of children and they are targeting states in which they do not live, okay, so third states, and they did not exhaust any kind of domestic remedies. So it was very similar. What we can say that these different human rights bodies, of course, adopted different solutions, but I think that the solutions that were adopted in these different cases are quite coherent. They are concurring to say that the jurisdiction issue and the victim status issue require a flexible interpretation in the light of the particularities of the climate proceedings and the climate issue. That is a peculiar one, and the cases show a will for adaptation, for a flexible interpretation of how to access the human rights bodies. So in all these cases, the human rights bodies considered that these two conditions, jurisdiction and victim status, were met. Okay, sometimes other conditions were not. For instance, in the jurisdiction criteria, the test that is used by the Committee on the Right of the Children and by the Inter-American Court was the following. So when you have a transboundary harm, the individuals that are victims, they are under the jurisdiction of the state on whose territory the emissions originated. So it's not the territory where they live, but it's the territory on where the emissions originated if, and you have three conditions, if there is a causal link between the act and omission of the state and the negative impact on the human rights, if the state of origin exercises effective control on the source of pollution, and if the harm suffered by the victim was reasonably foreseeable by the state on whose territory the emissions originated. So this is the test that was used, that was put forward by the Inter-American Court, and that was used by the Kiara case. But the European Court mentioned these two cases, but refused to use the test for jurisdiction. And the court said, so in the Duarte Agostino case, the case was very similar in terms of facts. So the European Court refused to use this test and said two things. First, if we look at the traditional case law of the European Court, there is no ground for jurisdiction for the 32 other states. Why? Because the other states do not have control over the territory of Portugal. They do not have a control on the children themselves. So there is no control. So there is no jurisdiction. The court said also that maybe we could have a specific test because it like a special feature for climate issues. And the court said that, okay, this could be an option, but in the end excluded it. And said that there is no ground for creating a new special feature for a jurisdiction. And even though the court acknowledges that states have ultimate control, that there is a causal relationship between the emissions and the human rights abuse, and also acknowledge that climate change has an existential nature, the court found it insufficient to create a new criteria for jurisdiction. So in doing so, the court is really limiting the access to the court and to human rights bodies for climate issues, and the court refused to adapt its competence and admissibility criteria to the specificities of the climate change litigation. But more than that, we will see later that maybe there is an adaptation, but it's an adaptation towards a restrictive approach and not an extensive approach. For the victim status, I'll be quicker. The UN committees used two criteria to consider that the applicant had the victim status. The risk of impairment of the right being more than a theoretical possibility. So this is the criteria used in the Torres Strait Islander case. And also they used the vulnerability criteria of the children in the Karasaki case and of the indigenous people in the Torres Strait Islander case. Same here, the European Court refused to use the same criteria and said that we need a specific criteria for climate cases, and this criteria is especially high. Okay, so the court called it especially high threshold to meet the victim status criteria. And in the three cases, the only applicant that managed to meet this very high threshold for victim status was the association of old ladies. And the court requires a direct impact on the applicant's rights and a particular level and severity of the risk. So for Article 2, this means a real and imminent risk to life. So this is very difficult to prove. And for Article 8, you need to prove an actual interference with the applicant's enjoyment of his or her private or family life. So it means no potential interference, but an actual interference. So that's the big difference. So as a result, nobody had this victim status except the association. And maybe to finish, the content of the obligation. So this is probably the upside of these judgments. The court did recognize two positive obligations. The first one is the obligation to adopt and effectively apply in practice regulations and measures capable of mitigating the existing and potentially irreversible future effects of climate change. So this is a very interesting finding of the court. So the states have to put in place these regulations. And the court also recognized a positive obligation, a procedural positive obligation to inform the public and to let the public participate. So this is classical for environmental obligations, according to the court. But the thing that struck me when reading the Swiss case was that the margin of appropriation that the court leaves to the state is a wide one. Actually, it's maybe more specific than that. Actually, the court said that there are two things. The first thing is the state commitment to the necessity of combating climate change, and this is a reduced margin of appreciation. So the state have to commit to the necessity of combating climate change. Okay. But on the measures that the state use to achieve this goal, on the choice of means, there is a wide margin of appreciation. And maybe if we compare it to the ICLOS case, which is of course different because the ICLOS is applying the UN Convention on the Law of the Sea and not, of course, the Convention on the European Convention on Human Rights. But ICLOS said, on the contrary, that the due diligence obligation, so the means that the state have to use to combat climate change, is a stringent due diligence obligation, that we have to reinforce it. So all this show that the European Court adopted a restrictive approach of its own competence and the admissibility of the applications, and it also adopted a restrictive view of the obligations of state, choosing to use a wide margin of appreciation as a criteria. Maybe in comparison, the other human rights body and ICLOS and other international tribunals or quasi-tribunals adopted a total opposite approach to address the specificity of climate change, saying that the specificities of the climate change litigation calls for an extensive interpretation of the instruments. Okay, I think that's it. Thank you so much for your attention. If you have questions there.